DWIs are very common in Texas, and it makes up a large portion of the people we represent in our practice. We have a great deal of success with DWI cases. We're known as experts. We've even been hired by attorneys and cops who've been charged with DWI. And we often get hired by other attorneys when their DWI cases are coming up for trial, and they start realizing that they're really a little bit over their head, and so they need a firm with expertise in DWI, and they hire us to help them. We speak at statewide seminars to train other attorneys to be better at DWI cases. We're known as experts in DWI, and we get the results that speak for themselves in DWI. You know, every type of person gets DWI in Texas. We've represented doctors and lawyers and teachers and construction workers, engineers, bankers, CEOs of large corporations, students. Just about people from every walk of life get DWIs in Texas. If you get arrested for DWI, that does not mean you're going to be automatically convicted. We win many DWI cases, even with breath and blood tests over the legal limit, all the way up to 0.33, even with that breath or blood test coming into evidence. Many times we're able to keep that evidence from being used against the client by having the judge suppress the evidence, find that that evidence was maybe illegally obtained, so it can't be used against our client. Many times we're able to show that the police acted illegally just in pulling somebody over, or maybe they acted illegally in detaining the person further than just writing them a ticket. Maybe they acted illegally in arresting the person. If you took a field sobriety test, if you blew, you took the breath test, or you gave blood, that does not mean you are automatically going to be convicted or that you've been legally screwed. We can often find ways to attack that breath test or blood test to show that it was inaccurate, to show that it was not properly conducted, to show that it was misinterpreted. Breath testing is wildly inaccurate. The machine that does the breath test is based on science from the 1950s that we now know is wrong. Yet they continue to use these breath test machines because they've spent so much money on them and because they give them an instant result, which they like. But just because there's a field sobriety test that you may not have performed beautifully on does not mean you will be convicted. Even if they're administered correctly, they are inherently unfair, especially under the conditions that they are administered, and we can show that people with nervousness or any other issues, not familiarity with those field sobriety tests, will probably not do well. You can possibly be over the limit without realizing it. Now, generally, for a 150-pound male, one drink, that'd be 12 ounces of a regular beer or 5 ounces of regular wine, or one mixed drink with one shot of approximately 80 proof alcohol, will contribute about 0.02 to a person's alcohol content. A person also metabolizes alcohol at the rate of about 0.015 per hour. Now, this varies from person to person and from time to time. Also, if there's food in the stomach, that will slow the absorption of alcohol. So there's many factors that play into how fast and how much alcohol affects a person and how much it contributes to an alcohol content. But it is possible for a person to believe that they're being responsible, but yet be over the legal limit. There are many defenses available to driving while intoxicated. First of all, not being intoxicated, okay? And just because there's a breath or blood test or an opinion of an officer that a person is intoxicated does not mean that a jury is going to find you intoxicated. Another defense is that you weren't in a public place. Another defense is that you weren't actually driving or operating a vehicle. A person may be sitting in their car with the car running, and an officer arrests them for driving while intoxicated, yet that doesn't mean a jury has to believe that they were driving or operating a car at the time. Now, those are some of the factual defenses, but there can also be legal defenses, such as whether or not an officer had reasonable suspicion just to detain the person. There may be legal challenges to the administration of the breath or blood test. There may have been improper procedures followed, improper warnings, improper instructions, improper usage. And those may be defenses to the evidence being used against the person. So there are many legal and factual defenses to driving while intoxicated. Anytime a person is arrested for driving while intoxicated, if they refuse a requested breath or blood test, or if they fail a breath or blood test, then their license may be suspended. However, a person always has a right to a hearing as long as that hearing is timely demanded. So it's very important to know about this and to have your attorney demand the hearing. By demanding the hearing, that keeps the suspension from going into effect for as long as it takes to have the hearing. And this is very important. That's how you know that you're okay to continue driving when we're representing you and we demand the hearing for you. But also, we can use that hearing as a chance to cross-examine the arresting officer at a time when that officer has not been coached by the prosecutor. These officers make a lot of mistakes. They have a lot of misconceptions about the law, and they will readily admit these mistakes and misconceptions at this hearing. We pin them down on that, and that may provide us with a way to legally win the case later in front of the DWI judge. We can often help a client get what we call an occupational license, so that if their license is suspended, we can get them an occupational license issued that allows them to drive to work and the other essential things, such as the doctor, the grocery store, the drugstore, taking their kids to school. We have experts in almost any area to help us with almost any issue that could be important in a DWI or other type of case regarding the blood testing, the breath testing, evaluation of evidence, fingerprint examining, firearms examiners, experts for every area. During your initial case evaluation, we will ask you many questions. We will find out as much as we can about your case. We will do whatever research we can online through the county records that are available to us at the point before we've been hired. We will start to evaluate what legal and factual issues may be present in your case. We will start to determine what steps may be able to be taken early on to help improve the chances of ultimately winning your case. We will determine what investigation needs to be done. Sometimes there needs to be investigation done quickly before things happen that may change the scene or the view. So it's very important to determine everything we can, investigate as much as we can about your case right away.